James Lee is partner and financial advisor of Metropolitan Wealth Advisors and has more than 20 years experience in the financial services industry. His areas of expertise include asset management and financial planning. Metropolitan Wealth Advisors is a wealth management firm that specializes in helping people tackle everyday financial goals, offering planning for retirement, tax planning, life insurance, estate planning, and asset management. James's presentation today is titled Estate Planning, a Sensible Approach. Thank you, James. The floor is yours.
Thank you very much, John, and welcome everyone. Again, yes, my name is James Lee. It's with Metropolitan Wealth Advisors. Before I begin, I just want to apologize because I'm a bit under the weather today. So if I happen to sneeze or cough, please just bear with me there. But today we're going to talk about estate planning, 10 common mistakes that we see out there. And actually what I'm going to do is stop my video so that way you can focus on the presentation. So as Ellie had mentioned earlier, we do have the group presentation, but one thing that we do agree to is that if you do have any individual questions, we're more than happy to answer them. Let me make sure. Okay, I'm sorry. I just wanted to check on one thing to make sure that screen sharing was fine. So you will have an opportunity to email us and ask us any specific questions that you may have in regards to your overall estate. Today, we'll talk about what estate planning means to you, a little bit about today's estate tax landscape, and not just 10 common mistakes, but I think of it more as 10 things that you really should be looking at when it comes to your own personal situation and estate planning. So when it comes to what estate plans mean to different people, obviously everybody's in a little bit of a different situation. You know, the reason why you would do estate planning, of course, is going to be different, but it's not only going to be different today, but it's going to be different even for you as you progress through life. Right now, it may be determining who's going to care for children. You know, I'm going to discuss this a little bit more in this workshop, but really when it comes to naming the guardian of children, of all the hangups that happen when people are trying to establish their will, who they're going to name as guardian tends to be the one thing that prevents people from finishing the documents. And that really needs to be done. Making sure that you structure finances so your loved ones are taken care of properly. Strategizing the best way to minimize costs. Establishing who's going to handle your finances, because, you know, if in the event that you have younger children or somebody in special needs, if you have a guardian, that's not necessarily the person who's going to handle the finances. Who's going to make medical decisions on your behalf, and determining whether your beneficiaries can in fact handle receiving whatever it is that you're leaving to them in a lump sum. But the reality is, like John was talking about, everybody needs estate planning. Everyone needs estate planning because, again, estate planning is not just for the rich. Estate planning is for everyone because it's really about organization. That's what we want to focus on, is making sure that everything is organized in a way that makes those that you leave behind, it makes it easier for them to handle everything. And it also directs exactly what your wishes are so you don't have to leave anything up for interpretation. If you're a person that has young children, like I had just mentioned, whether you have children from other marriages and you want to segregate assets, you could have grandparents that you want to, the grandparents may want to protect assets against the possibility of divorce, and they want these to go directly to their grandchildren. It could be in a business owner situation, or even, again, having special needs, because if you have a child with special needs, then you probably know you definitely don't want to leave assets directly to that individual because they could disrupt any benefits that they're receiving. Let's take a look at today's estate tax landscape. From 2011, 2012, it was 35%. That was the top tax rate for estate. Now, what I want you to remember is if we go back even further to maybe 2006, 2007, The estate tax exemption was 1 million. What does that mean? That means that up to 1 million, I could leave assets to my children. I would have no estate tax. Anything over 1 million would be subject to estate taxes based on a grid. Now, from there, estate taxes based on law continue to increase. And now we are at over $12 million per person, $24 million for married couples that you can leave without paying any estate taxes, which is great, right? However, and you may think, wow, 24 million for a couple, I guess I don't have anything to worry about there. Maybe you do, maybe you don't. But what you have to really remember is that even though it went up, it could just as easily come back down. They could change this from 24 million for a married couple to 3 million for a married couple or 5 million for a married couple. So to think that this is just going to continue for the rest of your life to have this exemption from federal estate taxes, I don't think is realistic. Last time I checked, the government needs money, and I'm sure that this is one area that they're going to try to reduce in order to start collecting more in the way of estate taxes. And then not only do you have federal estate taxes, but depending on where you reside or where you pass away, you could have estate from your state taxes or an inheritance tax. If you look at the states in blue, those states have an estate tax. That means that the state itself has set their own limit. That limit could be the same as the federal limit, or it could be a max at a certain amount, like 5 million, like the state of Maryland. What that means is that you have your federal estate tax, but your state also says, well, if you have over 1 million in assets that you pass, then as a state, we're going to have an estate tax of 10% as an example. So that would be added on top of your federal estate tax. And then there's the inheritance tax. If you are a non-lineage, so if you're not a direct descendant, then you would have what's called inheritance tax. So if you're a cousin or in-law, whatever the case may be, you could have an inheritance tax on top of the estate tax as well. If you live in a state that has the dark blue, which just happens to be Maryland by itself, then there is an estate and an inheritance tax that can really come into play. So just a few things that you should be aware of when it comes to estate taxes in regards to federal and at a state level. Now let's talk about 10 things we really should be looking at. The first is making a plan. So as I had mentioned, estate planning is really about making sure that your wishes are carried out, having it in writing so it's not left for interpretation. And we want to make sure by putting it in writing that by accident, things aren't going to the wrong people, that everything is directed the way that you want it to be. And in some circumstances, it may make sense for you to work with a team in order to make sure that everything does get organized. But what are the documents that every single person must have? You must have a will, a healthcare power of attorney, the durable financial power of attorney, a living will, and nowadays you need the HIPAA form in order to be able to gain medical information you were representative for. But let's talk about a will first. What's the purpose of the will? The purpose of the will is to clearly spell out who the rightful heirs are from your estate. When you take the will to the probate court, you're telling the probate court through your will that these people are my rightful heirs. If you do not have a will, then the probate court needs to assign an investigator, an attorney to determine who the rightful heirs are. And there's a matter of trying to prove things because, hey, you know, a cousin could come out of the woodwork and say, I was a favorite, and they said they didn't want to leave anything to the kids. Well, it's one person's word against another, and they're just going to have to gain as much evidence as possible when it comes to who should inherit, you know, whatever the estate is. So you don't want to have that situation where you don't have a will. Not only that, there are a lot of people that don't realize some of the quirky laws that exist with each state when it comes to people who don't have wills. As an example, in the state of Maryland, if you are married you have no children, and you have living parents. Most of us believe, well, if something happens to me, obviously it goes to my spouse, right? Well, actually, in the state of Maryland, the spouse gets a certain amount of money. I think it's something like 15,000. Then the spouse gets 50% of what's less, and the living parents get the remaining 50% legally. Legally, if you don't have a will. The point is to avoid any possibility of any of that happening by making sure that you put things in writing. And there also may be certain assets that you have. It is not necessarily something of any real value, but maybe you want to make sure that there are items in your possession that you want to make sure go to certain children, or maybe you have that agreement with the children already. And again, it's a matter of putting these things in writing, going ahead and listing them. This goes to this child, this goes to this child. So when the day does come, they're not trying to discuss among themselves, who gets what. So by putting all of that in writing and listing the items, if you have specific things that you want to go to specific children or people or institutions, then you can definitely do that inside of the will. Now, when it comes to naming the executor of the will, going through the probate process is not necessarily the easiest thing. But when you talk to somebody about whether they can be executor or not, which you should do, you should discuss it with someone whether they should be executor, whether they can be executor, because of the work that it entails. The executor has to submit the paperwork to probate. They have to take inventory of all the assets. So if you're not really organized and have everything neatly listed in an Excel spreadsheet, then it really becomes about waiting for mail to come in. See what statements exist, because you have to list everything for the probate court. Then you have to notify creditors to give them an opportunity to collect anything that's owed to them, pay any existing debt expenses and file taxes, distribute the property per the will to the heirs of whoever it's supposed to go to, and then you have to close out the estate. So, just because you name somebody as executor doesn't necessarily mean that you're really doing them a favor. You have to make sure that they are able and willing to do so. Not only that, with every one of these documents that I'm about to go through, you should have a primary representative or executor, and then at least two contingent. So two people behind an individual contingent. The one thing that we stay away from are co-representatives. And the reason why is because, again, it can, what we've seen in the past, it can create a little bit of confusion because there may be a disagreement on how to interpret certain things. We like to name one person at a time, but if the first person can't do it, then the second person would take care of it. If they can't do it, then the third person would take care of it. So again, one primary and two contingents, one after another, is highly recommended with all of these documents. And that includes the healthcare power of attorney. So the healthcare power of attorney is extremely important. You have to name a representative for that so they can make medical decisions for you when you're unable to do so. That could be picking doctors. It could be whether to do certain procedures or not. It could be changing hospitals. Whatever the case may be, you do have to name someone to be able to make those decisions on your behalf. And one thing that I'm going to mention is that with all of these documents, they do not have to be the same people. They could literally be 3 or 4 different people, or they could all be the same person. It's completely up to you. The power of attorney is also a very important document, and that's something that is very relevant for all of us because it's used while we're alive. So the power of attorney allows someone to make financial decisions on our behalf when we're unable to do so. Now, in some circumstances, it could be as simple as being overseas. Maybe you're vacationing in Europe for a few weeks and something arises and you need your power of attorney to take care of something here domestically. Or in most cases, what we've seen, if you're ill, maybe temporarily, you're in a hospital, whatever the case may be, you still need bills to be paid, and it allows your power of attorney to write checks, pay bills, do whatever it is that needs to be done on your behalf. And if you're concerned about whomever you name as power of attorney, the financial power of attorney, you can add in what's called springing powers, which means that the document for power of attorney is not valid unless it's accompanied by doctor's notes that state that you're incapable of making financial decisions. But like the other documents, you want to, make sure that you name a primary, a contingent, then another contingent. I mean, I have 3 children, and in having the 3 children, I'm probably not going to name one child for all of the different documents because, as many of you would know with different children, some of them are more capable in some areas than others. Then you have the living will. So the living will is something that I have personal experience in, stating whether you want to be kept on life support, whether you want to be fed for tube, how long you want to be kept on life support for, if at all. I mean, spelling these out, I can't even express how important this is. I can tell you, share a situation with you personally that a few years ago, my father, who was battling with cancer for quite some time, went through a bad spell. He was on life support, and all the family members were there, and extended family, and they had said, well, he had clearly stated that he didn't want anybody to see him this way, and we should just go ahead and relieve him of the suffering. But I was the medical representative for the living will as a representative, and it clearly stated how long he wanted to be kept on life support for. So instead of making an emotional decision or listening to everybody, everyone, look, I'm just going to follow the instructions. It doesn't matter what they say. A week later, he comes out of it, lives for another year and a half, and then the same thing happens again. And again, I followed the instructions. This time it went beyond the period, and I followed those instructions. So, I can't say enough after having gone through that myself, how important it is to have that in writing in order to relieve your heirs of needing to make that decision. That's probably one of the single most important things that you can do for your family, is to make sure that you don't put them through that. Then you have the HIPAA release form, which has to be done because that's something that allows your medical representative to obtain that medical information on your behalf. So again, looking at all of these documents, these are the very basics of what everybody needs to have. And usually when you do a will, it's a will package. So you would have all of these inside of the will package. I can't imagine somebody would do a will without the other accompanying documents. A little something that had happened previously with Heath Ledger. He was the actor from The Dark Knight. He passed away in 2008. He didn't redo his will. He did a will long, long, long ago, well before he had a daughter, and the entire estate went to his parents and sisters. Now, eventually, they did give the assets to his daughter, but it took quite a long period of time. And that's why it's important to make sure that we update our wills periodically. They say every 5 years, you should really just look at it and make sure that it reflects how you still feel, meaning who your beneficiaries are, or any of the other documents, how you want things done. And if they're still good, that's great, you can leave it. If not, then make the minor adjustments that you need to make. Setting up the guardianship for dependents, like I had mentioned previously, is really the single biggest hangup. For those of you that have young children, maybe you can relate, but it's always, maybe it should be my family, or maybe it's your family, or whatever the case may be. But the one thing that I have to say is, we hope that it never comes to that, but we certainly can't allow that to prevent us from finishing the documents. So we do absolutely need to name someone. And again, the person that we name as guardian does not necessarily have to be the person who's handling the finances. So that could very well be 2 different people. Many people may want to consider a trust. Now, the problem is when people talk about trust, they're like, oh yeah, I should do a trust and it'll protect everything. But I think people misunderstand what trusts are, how they work, and the different types of trusts that exist. When you do a revocable trust, so just think of it this way: anything that you can change, or you can stop, take away, whatever, anything that you can control, is still going to be included in your estate while you're alive. Whether it's in trust name or not, it doesn't matter. It's not protected. No tax advantage. If it's an irrevocable trust, which means it's completely out of your estate, if you don't have control, then yes, it does provide all of those things. But again, you're supposed to not have any control for those assets. But why would people do a trust? Mainly, they do a trust because they want to have control. A will dictate to the probate court who the rightful heirs are, and generally the trust will dictate how it goes to them. Or any restrictions that you would like to put into place, then you may do through a trust. What we find now is that most people are doing trusts because they want to make sure that the funds go to their grandchildren and not ex-in-laws. What I mean by that is that if I have assets and I leave it to a trust, when I pass away, it becomes irrevocable, so it's a separate tax ID. Now, my children may have direct access to that trust, so they can pull money out as they wish, but until they take money out, it's not theirs yet. So if they get divorced or they get sued or file bankruptcy, whatever the case may be, that money that's in the trust, even though they have access to it, is not theirs yet until they take it out. Most people are doing trusts because they want to make sure that if their children get divorced, half of the assets don't go to ex-in-laws. That's really the primary reason why I'm seeing people do that. And or if you want to create, excuse me, a certain restriction, such as I don't want my children to receive all the funds at once. I want it split over two different distributions or three different distributions at different ages, whatever the case may be. If you want them to, they have to visit my grave every month in order to keep receiving money. Anything that you want to put in there, you can put in there, but that's generally the reason why people would want to establish a trust. It's about retaining control and also spelling out any details in regards to the distribution. Now, the grantor is the person who sets up the trust. That's the person who establishes it. You name who the beneficiaries are within the trust. So the will would say the trust is the beneficiary, and then the trust would name the individual people. And then you have a trustee, just like you would name an executor of the will. Usually the executor of the will and the trustee are the same people. Again, they don't have to be, but usually we find that it is the same person. And when it comes to the vast array of trusts that exist, as you can see, there are many different trusts depending on what it is that you want to accomplish. And it really is revolved around that. What is it that you're trying to accomplish? Are you trying to save money on taxes? Are you trying to work against whether it's current income taxes or estate taxes in the future? There could be a number of different reasons why you do a trust. And whatever that is, there's one, I'm sure, that exists that would help you with your situation. So with state laws, because they vary, it's something that you have to take into consideration. You may want to establish a trust for a specific reason, but we have to make sure that there aren't any state laws that contradict what it is that you're trying to accomplish. And when it does come to trust, we do recommend that you speak with an estate attorney because there can be some complexities when it comes to that. It doesn't always have to be. Some of them are pretty straightforward, but it's worth at least a discussion and speaking with someone about how everything should be set up and what you should be looking at there. So with the federal estate taxes, something that's very important is that it does have to be paid. They're very, very stringent in regards to this. If you're leaving property as an example, and there's a state tax on that property, you're going to have to sell that property quickly because you have to pay the estate tax in cash. It's just something that needs to be done. That's why when we establish an estate, when we're doing the estate planning, one thing we always want to do is make sure that there's sufficient liquidity that's being left in order to pay estate taxes, so you're not forced to sell certain assets. And in some circumstances, that can even be the investments, that you don't want to be forced to sell investments when the market happens to be down like it is right this moment. By using a beneficiary designation, you can bypass probate in general. So anything that has a beneficiary designation bypasses your will and bypasses probate. I'll give you an example. Let's say my will states that everything goes to my children, but then I have an IRA account that has my sister as beneficiary. Well, all of my assets that go through probate are going to go to my children because that's what's listed on the will. But because my IRA says my sister's a beneficiary, that account's going to go straight to her. So you want to make sure that everything's aligned. And whenever a beneficiary is named, and that's through life insurance, your retirement account, as an example, it goes straight to the beneficiary so they can obtain those assets very quickly. All they need to do is file a death claim, have the death certificate and ID, and they can collect the money. And don't forget that your brokerage accounts that are not retirement accounts or even savings accounts, you can put a beneficiary designation on them. It's called a payable on death or transfer on death. It's a simple document. You name the beneficiaries, you sign it, and now those accounts, even if it's a savings account, you can, by having them on there, all they have to do is go there with those documents that I had just mentioned, and they can very easily get the money. Now, this is very important for those of you that have aging parents. There's no reason for you to be joint on any accounts. All you need is that power of attorney document. I know I'm going backwards on this, but that power of attorney document that I had mentioned previously, you don't want to be joint. You definitely want to just be power of attorney because that will allow you to handle everything that you need to handle rather than just being joint on a specific account. Sorry about jumping back, but that just came to mind. That's very important. But back to the beneficiaries, the payable on death and transfer on death, put that on whatever accounts that you possibly can because it'll make things a lot easier. Long-term care is really something that is very, very important. I think many of us realize that long-term care is now a real possibility. They say 1 in 2 people has a chance of needing some level of care. And it's really the only thing that exists out there. Now, you could have special medical procedures or whatever the case may be, but the cost for long-term care is the one thing that can really eat up an estate. And in many cases, from what I see, there's enough in assets to be able to pay if one person needs care. But what about if both people need care at different times? Is there enough in the estate to be able to pay for that? And if not, what are you doing about that? How are you addressing that possibility? It's something that we really have to take into consideration when we look at our overall estate. And in many cases, what I see, even those that know that they're leaving money to the children, in many cases, they will get long-term care, not because they don't have enough money to pay for it, but because they want to spend some of their children's inheritance to protect their inheritance by getting the long-term care. So absolutely something that we all need to be looking at. Income in respect to a decedent or IRD is another very important part of the estate planning process. This is one of the big mistakes that people actually make. And that is, if you have not paid taxes yet on accounts, then somebody will. And it's in regards to income taxes. This example, Jenny has 100,000 in personal savings and a 200,000 401k. The 100,000 goes to the heirs, no problem, okay, because it's in a savings account. But the 401k, remember, Jenny, when she put money into a 401k, it went in pre-tax, so she hasn't paid taxes on it yet, and she would pay taxes when she takes the money out. Well, because Jenny passed away and the money hasn't been taken out yet, when it goes to the heirs, it's going to be 100% income taxable to them at whatever their income tax rate is. So on top of their employment income. So it's very important to be able to forecast out in your estate plan how much of that money that I'm leaving to my heirs is actually in retirement accounts, traditional retirement accounts, not Roth, but traditional retirement accounts. Because you may not want to take money out of your traditional 401k or traditional IRA during your retirement because you don't want to pay the taxes on it. So you're just kind of defer. And then here comes 72 and you're forced to take out a certain percentage every year. And that's fine. But as you continue to defer, you're just creating a lump sum that your children are probably going to take. And then 40% of it's going to go to income taxes. So you really want to look at the efficiency of the withdrawals on those. You may want to take more during your retirement and leave less in the retirement accounts to your children. One thing that I always suggest is you look at your situation and your children's situation when you get into the retirement years. Is their income higher than yours? If it is, you should be taking more out of your retirement account to pay the taxes at the lower rate and reinvest it. If their income tax bracket is lower than yours, then maybe you want to defer. But in either case, what's most important is that you just pay attention to that. In regards to your beneficiaries, as I had mentioned, we want to make sure that the beneficiaries align with what we want. And it's okay to have certain accounts with certain beneficiaries as long as that's your intention. But just make sure when it comes to your will and your beneficiary for your 401k, IRA, or your insurance policies, that everything's set up, again, exactly the way that you want it to be. And then review it every now and then, because again, as you go through your life, you definitely will change your mind about things, that's for sure. And you want to make sure that everything that you have reflects the fact that you do change your mind. So like I mentioned, every 5 years is really a good idea. There are a lot of life-changing events that take place. We see it all the time where people really need to make adjustments. So if anything that you should take out of this, it would be, that you want to make sure that you review all of your beneficiaries of every account. And of course, don't forget about digital assets in this day and age. If something happens to us, we want to make sure that any of these online accounts that we have or digital accounts, they have to be shut down, and we need to give somebody authority to do so. So that's something that we definitely want to make sure is included in the overall documentation. So it's the digital fiduciary that we want to have included in the overall documentation. But with that, we discussed making a plan, the importance of putting things in writing, which is documenting your wishes, making sure that you nominate guardians of any dependents that you have. If you want to have a bit more control, then you should consider a trust. Make sure you're taking into consideration any federal or state estate taxes. Looking at the different ways to avoid probate by using beneficiary designations or putting things in trust name. Preparing for long-term care, the reality that long-term care does exist and it could happen to any of us. The income in respect of a decedent, understanding the income tax situation that's created there by not paying attention to that, updating your beneficiaries, and making sure that you don't forget about digital assets. I have my email there, and each of you, if you have individual questions, you can always feel free to email me directly. I'm more than happy to answer any question that you have. So you are definitely privy to do that. And with that, I can open it up to questions you may have here.
We have 7 questions that were asked. So I think we'll probably have time to get all of them. First question is, what happens if you go through the named executors? Who handles the probate of the will? In other words, if the named executors of the will are no longer alive or available to handle the probate, what happens? Who handles the probate of the will?
Yeah, you would likely, a family member would have to petition to be the representative or executor. I just never really see that happening. The reason why is because obviously if the first person you name is no longer alive, you should be redoing your will or documents anyway. It shouldn't come down to the second or third person before you decide to redo the documents.
Well, coincidentally, we just received notice of an estate coming to the University of Maryland, Baltimore, where this exact situation is in play. The 2 named executors are both still alive. However, they are not they're not in a position to administer the estate. And it looks like the petition to the court was for the close friend of the deceased to become the new personal representative.
Yeah, that's why in going through this workshop, we really try to emphasize the importance of updating documents as necessary. And all it takes is an amendment. In some circumstances, you don't have to redo the complete documentation. So, as events take place, such as that, I mean, that's an event. If you have one of your representatives or executors pass away or incapable of being able to execute their duties, then that's definitely an event to update your documentation.
Okay, great. Next question is, what is the difference between a healthcare power of attorney and a living will?
So the healthcare power of attorney allows you to make medical decisions on behalf of that particular individual. So again, it could be choosing a different doctor, it could be choosing a different hospital, your basic medical decisions that are made. The living will is really about those final days of life support, to be honest with you, whether you want to be kept on life support or not. It's more dedicated toward that.
Okay. Question number 3 is, if you have a healthcare power of attorney, what additional info would be released that would require a HIPAA release?
Well, that's the HIPAA release form is a very specific document. And because it's become mandated now, it's just a separate document that you have to have. It's a very specific document. The HIPAA release form in itself is what you need to get medical information. So if you have the power of attorney, if you have the HIPAA release form just by itself, it doesn't mean you can make medical decisions. It means you could obtain medical information. So the healthcare power of attorney allows you to make medical decisions, not necessarily gain the medical information, the private information. So that's why it's important to have both. Not every state may necessarily require both documents, but it's good to have both anyway, just in case.
Okay, thank you. Next question is, I have been told that in California, at least, one needs a trust to keep your estate from going through probate. Is this true in Maryland?
No, remember, beneficiary designations bypass probate, but we're always going to have some probate assets. So any possessions that we have to go through probate. So my home will go through probate. The assets within my home will go through probate. My car, so everybody's going to have something that goes through the probate process itself. But the purpose of having a beneficiary designation is that those particular assets will go to that individual directly. We don't have to wait for the probate process before they can collect the money. They can collect the money immediately. So that's the importance. As far as Maryland goes, you do not have to have a trust at all, but everybody needs to have a will. But in the state of Maryland, you don't even have to have a will that's done by an attorney. You can do something, you can put something in writing and have a couple witnesses or have it notarized, and that would be sufficient. I'm not suggesting that you do that, but there are a lot of documents that can be obtained even online. You don't necessarily need to use an attorney. You can use some of these online documents if your situation is pretty straightforward. It's better to do that than to not have anything at all. Definitely, I would recommend that. But no, you do not need a trust in Maryland.
I'm going to insert a follow-up to that question myself. So in theory, though, if you did have a trust and you titled your house, you titled your car, you titled everything that has a title to the trust, would that then avoid the public scrutiny of the probate process?
Yes, I mean, that's one reason why people do title those assets, but many people don't title those assets. The reason why is because they change them throughout their lifetime.
Mm-hmm.
So I don't want to go through the hassle of car under the trust name, knowing I'm going to change my car in 5 years. You know what I mean? So usually it's assets that you're never going to change, then it would be okay to do that. That's one way to make it happen.
Okay. Next question is, why is it not good to be joint on an account?
That's really a great question. I love that one. The reason why, and when we say joint, we're more specifically relating to being joint with a parent. Okay. So if you are on a joint account with a parent, technically half of that account is yours. So let me use this example. Let's say your parent is very conservative, has 300,000 in a savings account. Okay, fine. So you're a joint. That technically means 150,000 of that is yours. You get into a car accident, you're sued. 150,000, half of that account is part of your assets. Okay, even though the likelihood of that happening is slim to none, the bottom line is, I mean, even if you were to have any sort of obligation, that is technically part of your assets. Now, let me bring in a different scenario. Forget about the savings account. Let's talk about an investment account or a home. Well, if you inherit a home, then you get a step up in cost basis. So if my mother paid 500,000, it's worth $1 million. I inherit it. When I sell it, I don't pay any taxes because the new cost basis is her date of death value. So that was $1 million. If I am joint on that, then I inherit her cost basis of 500,000. So that means that when she passes away, my portion, 250,000, could be taxable because of the fact that I inherited her original basis. I didn't get a step up in basis by being joint on the account. It's even worse when it comes to investments. So there really is zero reason whatsoever why you would ever need to be joint on an account with a family member or a parent when a power of attorney handles all the same things. All you need is that document, and that way you can properly inherit items and take advantage of the step up in cost basis and also not have that commingling of obligation. It's just not necessary.
For legal liability. Yeah. Okay. Can you be both a power of attorney and joint on an account?
Oh yeah,
Okay.
because the power of attorney is really just related to your ability to make financial decisions for a specific person. So that's their portion.
Okay. Next question is, when two individuals, X and Y, are joint owners of a savings account, but a third person, B, is named as the beneficiary, what's the sequence of distribution? If X dies, does it go all to Y?
It depends on how it's titled. If it's joint with rights of survivorship, then it would go from the first joint person to the second joint person, then to the beneficiary. If it's joint tenants in common, that means that the two joint holders, they don't necessarily have to be 50-50, but their portion will go straight to the beneficiary. So it's just a matter of how that joint account is titled.
Okay, so follow-up question is, can you actually title a savings account joint tenants?
Oh yeah,
Yeah, okay. Tenants in common, not with rights of survivorship. Okay,
correct.
okay. So it can be titled either way.
Yes,
In other words, you either each party owns 50% of the asset, or each party owns 100% of the asset. They both have the equal rights of the asset.
well, and it doesn't have to be 50-50. If you're
Oh.
tenants in common, it could be different percentages.
I see. Okay. Okay. Next question is, when a child inherits a 401k, does it have to be cashed out immediately, or can it be rolled into their own retirement?
It can be stretched out. It used to be they could stretch it out over their remaining lifetime. That rule has changed. Now it has to be taken over a 10-year period if you stretch it.
That
You don't-
includes 401ks?
That's correct. Any
Uh-huh.
retirement account, traditional retirement account, we're not talking about Roth because they're not income taxable to the next generation. But a traditional retirement account, whether it's a 401k or IRA, they have to take it over a 10-year period of time. If they do not stretch it for whatever reason, then they have to take it over a 5-year period of time. But the one thing that I can say is, being in this industry for 30 years, there are very few people who stretch it over the 10-year period, whether they need the money or not. And that's the problem, is that it's the attitude that people have toward inheritance versus those who earn money. It's amazing when people inherit money, they don't care about paying the taxes, but yet they complain every day about the income taxes that they pay on their earnings. It's like you win the lottery, you don't care about the taxes that you have to pay on it because it wasn't yours to begin with. So too many people take it as a lump sum and then they just pay the taxes, regardless of whether it's 35 or 40% that they pay. So having seen all of this, that's why I recommend for people to really try to reduce the amount that they're leaving in general in retirement accounts because of the taxation that's going to incur. And if you do lose 40%, well, that's 40% that you could have just spent during your lifetime and enjoyed it rather than paying taxes on it.
Okay. This next question, I'll ask the general part, but it's from an anonymous attendee, and I might encourage the attendee to email you directly the second part of the question. The question is, do you provide services to state employees? And if so, how, basically, how are your fees assessed?
Yeah, I mean, that's something that I would just answer individually. But yes, I mean, we can help anybody. It doesn't matter where you work.
Okay.
Your situation is your situation, and that's what's most important, and that's what we want to address. So,
Okay.
the purpose of us being here year after year is we want to be able to provide the best information possible, and make sure that it's the best and accurate information to your situation, not somebody else's situation, which is why we do make it available for people to contact us directly.
Okay. This is a controversial question, or I should say the answers to it are a little controversial, but what do you think about online will creation, like Willmaker?
There are a lot of different legal documents that you can obtain online. I think that they're fine if your situation is pretty straightforward. Again, it's better than nothing at all. If your situation is a little bit more complex, or you have, very specific things that you want to do, and you're not familiar with those documents, then you should use an attorney.
Next question is, can you give an idea of when one should get long-term care insurance, parameters of when it makes sense?
Yeah, that's a common question. I mean, there isn't any perfect age, but you have to remember when it comes to long-term care insurance, it's based on your age, your health. So the older you get, the more expensive it is. And also the older you get, the more likely you're going to have, certain medical issues that may prevent you from getting long-term care, or even increasing the premium for long-term care. Long-term care insurance nowadays has changed quite a bit. Those old days of just paying for a certain amount of care for a certain number of years, and then you use it or lose it. Those days are pretty much gone. Most financial planners or people in the insurance world will use the combination of the life insurance and long-term care together. And the reason why is because then, no matter what, whether you need care or not, at least the kind of proceeds go to your heirs. So something goes to someone rather than it just going away. But that's a whole another conversation there. I would say that a sweet spot is really in your late 50s, maybe very early 60s for long-term care.
Okay. And incidentally, our third speaker today is going to go in depth into this subject too. So I encourage the person who asked that question to, if they're available, to attend our third presentation today. Next question is, can a will designate a guardian for minor children as someone other than the co-parent? Or do the children automatically go to the co-parent if they are alive?
Yeah, there are different, I mean, I don't know if there are different state laws in regards to that, but generally that would be the case. I think it depends on what the legal situation is between the two parents. That's a little bit a little bit complex. I mean, that's
It's really a legal question too.
yeah,
A
more so
lawyer
than
might
estate
have to
planning,
answer that.
right?
Yeah, yeah. Next question is, do executors get paid when fulfilling this role? If yes, what is the fee and how is it determined?
Yeah, that's, it can be whatever you want it to be. I can tell you that if you hire an institution to be the executor, then they may charge, as much as 10% of the estate value. But, if you name somebody as executor, more times than not, we tend to see them leave some level of compensation. Unfortunately, I can't tell you exactly how much you're supposed to, compensate them. It just depends on the situation. It really does. But yes, in some circumstances, or in many circumstances, we do provide some compensation for the executor because it is a lot of work.
Okay, good. Next question is, what type of lawyer should I look for to create the documents you spoke about?
Well, generally an estate attorney. When you look up the different attorneys that exist, they'll clearly list if they're an estate attorney or not.
Yeah, I think the magic words I've seen are trusts and estates. That's how attorneys will often hold out their services. Next question is, can an executor be a recipient in the will?
Yeah, absolutely. Many people will name their children as executor or representatives.
Mhm.
The one thing that I will say is that if your children are executors and representatives, then it's kind of pointless to put any restrictions on a will or trust. So I have 3 children. If I name them as the executor or trustee, but then I tell them, you know what, you guys can only take money, when you're 25, 35, and 45, right? Well, when I pass away, there's nobody to police them. The 3 of them could get together and say, you know what the heck with this? We're just going to take all the money at once. Nobody's there to police them. So, having restrictions is kind of pointless, to be honest with you, if the beneficiaries are just going to be the executors or trustees. It's okay as long as you don't have those restrictions.
Okay, next question is, and it looks like we have time for about 2 more questions. How can a family have permission to go into your bank account immediately if something happens? The bank usually freezes it.
No, I mean, if you have, it depends on what's happening, right?
Mhm.
If you have a power of attorney document, that power of attorney document acts as if you are the individual themselves when it comes to financial matters. So if you present the power of attorney documentation and, along with your ID, then you act as that individual from a financial standpoint.
Okay, great. Last question. And then I'll say the unanswered questions really, they're both actually legal in nature, and I would encourage both of the attendees who asked the questions to attend our next presentation and ask the attorney who's actually presenters number 2 and 3 are both attorneys. So either one of them could answer these other questions. But the final question of today is, do the words and or make a difference on joint accounts, CD, money market, savings, checking, etc.?
Well, yes. I mean, it can't be. When you have a joint account, it's going to be and.
Mhm.
I mean, that's just pretty much the way it's going to be. Otherwise, it's not going to be joint.
Have you ever seen or on the title of an account?
Not that I can think of.
Okay. Well, that's all the time we have for questions. Thank you again, James, for your presentation. Thanks again, James.
Okay. Thank you, everybody. Have a wonderful day.